Okay, so good morning, everyone. I'm Kara Cookson. For those of you who don't know me, I'm with the Office of the Maine Attorney General, and I'm the Victim Witness Advocate Coordinator. And this is the third in our virtual mini series that we're doing over this spring and summer, and we'll come back around to it this fall. I'm joined by Tessa Mosier from the Maine Department of Corrections. She's the Director of Victim Services. And today she's going to give us an overview of corrections. And we need to make sure that everyone is muted. I should have brought up the housekeeping in advance. So she's the Director of Victim Services. She's going to talk about everything corrections, things that some of the vocabulary around sentencing and how some of those things work, and also just talk about the services that are provided to victims at DOC and how advocates and other professionals in the community can link in and collaborate with what DOC has available. So some housekeeping pieces for today. Tessa's going to be working from a PowerPoint, which is great. Definitely keep your sound muted, and I'll remind you, or I may be able to go in and mute myself if you need my help. Jump in at any point, though, if you want to ask a question, just unmute yourself. You can also put questions in the chat, and I'll either help kind of get those into Tessa as we're moving along, or we'll save those for the end because we did build in a lot of time at the end for questions. So without further ado, let's welcome Tessa Mosier. Thank you, Tessa.
Thank you so much, Kara. I really appreciate the opportunity to talk about the Maine Department of Corrections Office of Victim Services. And I want to thank you for putting together the virtual trainings that you have. It's really imperative and essential to our work. And so thank you very much for that. As Kara had stated, my name is Tessa Mosier, and I work in Augusta at the Maine Department of Corrections Central Office. And I work with probation and parole. And so there's a few different things that I'll mention about probation and parole outside of the PowerPoint, and also if there are questions that you have about anything specific to probation and parole that's not mentioned, certainly feel free to ask, as Kara had said, or ask for additional information. So I'll use this time to go ahead and get started with the presentation. And thank you, Kara, for monitoring the chat. I'm not able to see it from this presentation that I'm looking at with the PowerPoint. So you should all be able to see the introduction to the Maine Department of Corrections Victim Services. And so if you can't see that, then let Kara know, because you should definitely be seeing the PowerPoint that's on the screen. The mission of the Office of Victim Services, it's to make sure that we are providing victims with information according to their rights. We want to make sure we're treating them with dignity and respect, and also that we give referrals to other victim service agencies as appropriate. And we'll talk about a lot of those other agencies that we provide referrals to. And we work with victims who are the victims of either our residents who are incarcerated at one of our prisons, or victims of anybody that is out on probation and parole. And so parole was abolished in 1976 in Maine. And so the majority of the clients that we do have out on probation are in fact probationers and not parolees. However, it's important to mention there are a few folks that are still eligible for parole.
I'm just going to jump in. We've got somebody on the call who needs to mute.
Yeah, but if you
I'm trying to do it myself.
Be considered a report, I do have to report it to CPS.
Got it.
So the learning objectives that we want to have within the PowerPoint is that the participants will be able to know about the DOC Victim Services and who is eligible to receive the services that we do in fact offer. We would like to have an ability for the participants to know how to assist victims within the DOC victim notification request process, collaborate within the DOC and refer victims for assistance with corrections related issues, including notification, restitution, VOD is short for Victim Offender Dialogue, CBIP, which is Certified Batterers Intervention Program, and post-conviction release and safety planning and what that is. And then also we want to make sure that you know about the DOC Victim Offender Dialogue and how to refer victims who wish to request a victim offender dialogue. So throughout this presentation, these should be some basic learning points that you should come away with as far as the DOC Office of Victim Services and the services that we do in fact offer here to victims in which we work with. I start off with the presentation by talking about the Office of Victim Services and the statute pertaining to the Office of Victim Services. So sometimes people aren't aware that it's actually embedded in our Maine legislature. And so here's just a summary. It's in 1214, 34A 1214. And so it talks about advocating for compliance with the laws and then also assisting with any correctional facility, detention facility, community corrections, or contract agency, as well as making sure that we're working with victims properly, that victims are receiving their rights, that they're treated with dignity and respect, and that our policies and procedures are all including such when we design and implement new policies. And so it talks here about, what I do, who I report to. I report directly to Deputy Commissioner Ryan Thornell, and his direct supervisor would be Commissioner Randall Liberty. So that's my chain of command essentially throughout the Department of Corrections. And then I select victim advocates to help me carry out these statutory functions. Currently, we have 2 victim advocates that work in our office. Lynn Boynton is one and Nicole Fallon is the other. And then I do have an office associate, Sarah Dosty, who helps us with the notifications that do go out in writing, and she monitors all of that notification and ensures that we're in compliance with statutes and whatnot when sending those out. And I will talk more about those notifications later on in the PowerPoint. And so we also, as part of the statute, receive or refer complaints made by victims. So what that means is that if I receive a complaint by a victim about something that's happening that they're unhappy with or that they're filing a complaint on, we look at that and we take a look at our policies to try to figure out if it was something that should have been done, and if so, address it. And then if there's something where we're missing information, then we can research and look into that. And then also sometimes it's complaints about being harassed by maybe someone that's in our care or custody at the Department of Corrections. So those are other things we can assist with as well. And so with the complaints, we want to try to make sure that we can resolve the complaints as quick as possible. And just to give an example, a complaint might be that a victim wanted to have victim notification prior to an offender being released from incarceration, and they weren't. And so what we would do is we would look to see if the victim was in fact registered, and if they were, why were they not notified? And if they weren't notified, if they weren't registered, then we would look into getting them the information that it was and explain the notification process and why they weren't notified. Because the notification starts with a request on behalf of the victim. So that's a common complaint that we get when someone isn't notified. Intercede on behalf of victims within the officials of the Department of Corrections. And so if there's an issue or complaint or concern that's noted by a victim because of one of the facilities or something that's happening in the department or probation and parole, then we try to work with the victim to address those issues and to try to get a resolution that is suitable for everyone. And then also, of course, most importantly, I think, is acting as an information source for the rights in making sure that, again, that we're treating victims with dignity and respect, and making sure that they know about what their rights are, making sure that they know about victim notification and the options pertaining to that, making sure they know that they have a voice, and also just continuing to be a voice for them if they're requesting such. So one of the main factors of the victim notification process is that it has to be, according to statute, upon a victim's request. So once a victim makes a request for notification of a prisoner or juvenile release, then we enter that information, and part of our duty is to ensure that those victims get those notices. And then we also assist victims who are being harassed by persons in the custody or care of the Department of Corrections. So for example, if you have someone in the community that feels that they're being harassed, or they're getting maybe unwanted mail, or something is happening that they want to cease, then we can interject with that community member, even if they are not previously identified as a victim prior to this, and we can assist in getting harassment warnings served on the resident that may be incarcerated. And then we can also provide support services for that community member to be able to give them information and talk about what services we can offer next. Because according to our policies, if someone has a harassment warning or a protection from abuse order, then they can also request victim notification, even if they are not the direct victim of the current crime in which the resident is incarcerated. So I think that's important for people to know, because if someone is in the community and making a complaint, they do not necessarily have to be identified as a direct victim in order for us to assist them. And it happens sometimes with the unwanted mail. And so we may have a resident that has found someone's address through another resident, or maybe they found information on someone in the community, and so they start writing or trying to contact them to see if they want to share correspondence. And sometimes it can be upsetting or considered harassing to the people in the community. So those are things that we can work with. And then of course, if they are already a direct victim and any type of harassment takes place, we can work with the victim in the community to get a harassment warning served if it falls under the definition of harassment and whatnot. So we also assist victims with obtaining victims' compensation, restitution, other benefits of restorative justice, such as the victim offender dialogue. And then I also advise the commissioner if I believe that there's a risk or safety issue to any one of our incarcerated individuals. And so that's the last part of this section here, to ensure the safety of clients who are also victims, to make sure that the commissioner is aware. And because we don't want to pose any additional risk to somebody that's incarcerated as well, that happens to also be a victim. And then finally, the statute talks about the confidentiality of the information that we have. And so this is one place that addresses confidentiality. And throughout the presentation, I'll also talk about other statutes that protect victims' information and confidentiality of such. And so this is one thing that's definitely outlined and clear in the Office of Victim Services statute. And then also, we cannot release information about victim notification and who has asked for victim notification outside of the department or with the Office of the Attorney for the state in which the request was filed. And so I cannot share that information with anyone other than those within the Department of Corrections, if necessary, in order to fulfill their duties, or with the District Attorney's Office or Attorney General's Office, who has in fact submitted that request for the victim. And we do that, and it's obviously because it's in the statute, but it's also to ensure the protection of victims who ask for such requests, and also so that we can reduce any victim blaming or a chance any information gets shared that shouldn't be about a victim, the name, contact information, location, where they reside, etc., because we do not want to jeopardize their safety by having any information shared that should not be. So sentencing options in which we work with victims and work with explaining what each different option means to victims is always helpful. So when someone's incarcerated, we all know that they can either go to the county jail or they can go to a DOC facility. And so when I'm working with a victim, I can let them know where they're at, where the resident is, if it's the Maine State Prison, which is in Warren, if they're at Bolduc Correctional Facility, which is also in Warren. We have Charleston Correctional Facility, which is in Charleston, Maine. It's actually called Mountain View Correctional Facility, which is in Charleston, Maine. It was formerly known Charleston Correctional Facility. And then we also have Maine Correctional Center in Wyndham. And then we also have Southern Maine Reentry Center, which is where the minimum security female prisoners are, residents, excuse me. And so when we talk about incarceration, we talk with victims about where they are at. And sometimes we receive calls when people are at the county jail. And so usually that means less than 9 months in a day, generally speaking, would go to the county jail. And so more than 9 months in a day, the person would come to the MDOC, one of our facilities. And so we talk about where they're at and what the sentence is for that incarceration and explain things such as, what does suspended mean? What does all but suspended mean? And what does probation mean? And what does it mean if there's a violation? Those are things that we talk about with victims regularly. We talk about what probation is, what can happen for the length of time with probation. What happens when there's a probation violation filed? We talk about the tolling of probation when a violation is filed. So it essentially stops the clock for probation while that violation is still pending. And so we explain those things so that a victim will know what to expect and how long they can expect for a person to be on probation. Now, then we also explain what happens if their probation is violated, that there could be anywhere between, a warning, graduated sanction, which could be, adding a curfew. It could be a matter of additional drug testing. It could be a matter of, more tests for the use of alcohol. It may be that they do serve some time in jail. And then it may be up to the full amount of time that they have left on their sentence. And so we explain all those types of things to victims to ensure that they know that probation violations don't always result in an immediate return to serve the remaining portion of their sentence, because lots of times that's a misconception that victims have. We can talk about fines and assessments, although the DOC Victim Services doesn't specifically have any involvement in fines and assessments, but sometimes people will ask and we can refer them to the appropriate agencies for that, such as the courts or the business office, if we need to know if someone has in fact paid their fines or assessments, etc. We work a lot with restitution, and we do have a victim advocate that works with restitution and works with victims who are to receive restitution. We explain the policies regarding collection of restitution that is implemented at the Department of Corrections when the court order or probation conditions do not specify the payment plan. And so our policy outlines what the payment plan should be set at. And so we talk about restitution and what happens if it is not paid in full when they end probation, what we can do to communicate that information with the victim and with the district attorney's office, and also talk about any relevant statutes when we're explaining restitution. The community service is also lots of times ordered as part of a probation condition. And so lots of times victims want to know if an offender has been in compliance with those. And so we can talk about what the community service ordered was, and then try to answer any questions that we can about that. And when someone's on a deferred disposition, generally speaking, the DOC Victim Services does not have any involvement because generally they're not on probation for a deferred disposition unless there's some other charge that they're currently on probation for. And so that's also something that we have very limited involvement in. However, it's important to mention because sometimes victims will call asking for services when there is a deferred disposition, and we would refer that victim back to the district attorney's office, victim witness advocate. And we work with programming, the batterers intervention programs, and then the sex offender treatment programs, as well as the possibility of administrative release. And if there is an administrative release, what are the conditions involving such? So that's information we can share from the sentence or the court documents with a victim, and we try to explain it the best that we can and refer accordingly if it's a case where the person is not on probation. So with incarceration, we have the different types of incarceration where I had mentioned the county jails and the 9 months in a day or less, excuse me, 9 months in a day, yeah, or less, and then 9 months in a day or more. And so if it's 9 months or less, then we go to they go to the county jail. And if it's 9 months in a day or more, then they'll go to the DOC. And that's when we can work with victims and file victim notifications and continue that process. So a couple of different terms that I think are helpful is a split sentence or concurrent. What is time served? And these are all things that we explain when we're working with victims, because a split sentence may mean that they serve some time while they're going to be incarcerated, and then they have the remaining time that's suspended, and then there may be probation. And so what happens is if you have an example of, say they had a 10-year sentence, all suspended but 5 years with 4 years of probation, the person will actually serve 5 years and then be released to start serving the 4 years of probation. Now, if probation is violated, then they could serve up to the remaining 5 years that there would be on their sentence, because it was 10 years, all but 5 suspended. So the all but suspended part is what is important for victims to know. That's what is the time that a victim will be, or that's the time that a victim should know that the offender will be serving, minus any good time, plus any time served that they received credit for at the county jail. Or they could also have a sentence that means time served. So any time that they had already served in a county jail, or if they were at the DOC as a safekeeper or boarder, any time that they had pending conviction, they may say that they have time served. And so the time that they served was adequate, and that's what the sentence was, is that they were to be incarcerated for that period of time that they've already served. And so they are then released to the community. And here's some good time statutes. I did just briefly mention that the example that I had given with the 10 years all suspended, but 5 years to be served with 4 years of probation, that 5 years that the incarceration period of time means it will be minusing any good time earned. So these are the good time statutes that our residents at the MDOC are able to earn, and if they're at a county jail, according to the time that they were sentenced. So if it is the 2004 code, then a resident or a county jail inmate could receive 9 days a month. And then there's exclusions for domestic violence crime types and sexual assault crime types. They're familiar cases. And so if it's a crime against a family member with the domestic violence and sexual assault, then they are not able to earn that additional 4 days a month. So the max that those folks could get is 5 days a month.
Tessa,
Yes,
I'm going to slow you down for a second. Here's an overarching question. That's a good one. Go back to that slide. But the question is sort of, well, isn't the 2004 code the most recent? Why doesn't the 2004 code apply to everyone?
right. So it has to do with the time that they were sentenced. So depending on what code was in effect at the time of sentencing is what continues with them, and not the code that is the most recent and in effect now, because they're actually all in effect. And as far as the Department of Corrections goes, this is not something that I interpret or that I prepare good time earned, or the number of days or any involvement in such. And if I have questions, then I go directly to the classifications department, who prepares all of the different good time deductions based upon their behavior. And also, I just like to point out the different codes, because it really gives an opportunity and really insight into how early someone could in fact be released. And so it's important for victims to have that accurate information in order for them to be able to safety plan properly. So Kara, that's an excellent question, but it does go to the fact of when were they sentenced, and then that particular code applies. So we had just mentioned the 2004 code, but if you look down to the 1983 code, some of the residents were able to earn 15 days a month. And so that has a significant impact on when a resident will be released. And it just exemplifies the importance of a victim needing to be able to have that information about the accuracy of how much time will really be served. So for example, if you have a murder conviction and someone received 60 years sentence straight without probation, and they were sentenced on the 1983 code, then they could get up to 15 days a month off their sentence. So the 60-year sentence, that could potentially allow the person to be released after 30 years. And so that's information we share and explain to victims to be sure that they know, so that they can plan into the future. And it also goes to the importance of ensuring that victim notifications are on file, so that we can make sure we know where the victim is at, and we can get them the information on this projected information on release dates. So
Thanks, Tessa. I was just going to say, I think part of the issue too is just like legally, the legislature can't go back and change the rules for someone who's already sentenced, which is why we have to hold on to each of the code sections, right? Is that why it is?
I would have to defer to an attorney for that, Kara, to say specifically, but I believe that that's always been why. It's based upon the time that they were sentenced in, under which understanding of which code they were going to be having their time applied, and according to each statute. And so they are, when they take a sentence of a certain amount of time, then they're under the impression that they will be receiving up to that amount of time of good time. And so if you were to change that, then you would be ultimately changing what they had agreed to at the time of sentencing. And so it's always been my understanding as to that's why we go to the code in which they were sentenced, and the statute does in fact specify that now. Now, what would happen if the statute were to change and say that it's the most recent code? Then that would be another thing. But as it is right now, you have to go exactly by when you were sentenced, or when the resident or individual is sentenced. Does that help, Kara?
I just wanted to make sure that piece was clear. That was my understanding in the state that I practiced in, and I would think that that's probably the law here as well, that you can't retroactively go back and change things, but it certainly
Right.
makes it complicated for you all, doesn't it?
Well, and thankfully, our classification department does an excellent job at trying to calculate all of these good time statutes and whatnot. And they're really the experts in trying to look, when the sentencing was, how much time can they get? And then they capture all of that. But as of now, we do go by the time of sentencing. In the future, if these statutes were to change, then it's hard to say, what that would look like. But it is according to the laws now, it's when they were sentenced. And so if you're ever trying to assist a victim, this is where you want to go in the 17A to try to find out what amount of time they could in fact get. But I think it's really important to talk to victims about the ability for someone to earn good time so that they don't think or expect that the full amount of time sentence will actually be served, because that's not accurate, because they can get this 9 days a month from the 2004 code, 5 days a month from the 95 code, and then up to 15 days a month. They're all up to, on the 1983 code.
Great, thank you.
You're welcome. So we have the other forms of, in quotes, early release. And so some of these are different. So as you'll see, you see furlough, administrative release, supervised community confinement, and then parole. And so I'll talk a little bit about each one of these things and what they are. And so it's important for you all to know as well what we do and how we reach out to try to get information to help us when these types of things are happening. And so according to the statute, if there's a victim notification, then the victim must be notified if a resident is approved for furlough, and they must get that information of when the furlough is going to be, for how long, and at what address, and who the sponsor is. But then we take one step further with our furlough policies, is even if a victim hasn't registered for victim notification, we do try to locate victims and reach out to them regardless. But it's much easier if we have that contact information for the victim already, because then we know that they do want to be contacted. And we have not ever had anybody tell us that they did not want us to reach out and that they wished we hadn't. And they're always very thankful for the information, although some people still do opt out to further notifications or further information. But a lot of people do comment about the process, and they do end up registering for victim notification because of our reach out. But so a furlough is a release that happens from one of the DOC institutions after a full investigation has been done, victim input has been considered, and a decision is made to allow the furlough. And so there's limited periods of time for furloughs. They can be up to 72 hours in the community with the sponsor. So a furlough could essentially allow, in a victim's term, to go home for the weekend. And so what we do, though, is we want to really get that victim's voice. Some victims do have safety concerns, and if that's the case, we want to make sure that we are the voice for them throughout the furlough investigation. We make sure that the probation officer who's doing the investigation has that information to be able to include in their final report and recommendation before the team makes that final decision. And so if we don't have the information for a victim, then we do try many different ways, which one is reaching out to the district attorney's offices to try to see if they have the victim contact information, which is always really helpful for us, so that we can ensure that that victim has an opportunity to provide input. Lots of victims do want to provide input, but there's also lots of victims that don't have any comments or concerns. And so that's just information that we take and relay for them. And it's also, as I've stated, just a really good opportunity for us to connect with the victim to talk about DOC victim services, and to also ask if they would like to have victim notification and any further contact from our office. And so that's really helpful for us. And then we also look to see if any other resource information should be provided. So is this a case where maybe a victim had a loss and they should be referred to victims' compensation? Or is it a domestic violence case, and should we refer them to one of the MCEDV resource centers? Or is it a sexual assault case and we should send them to one of the resource centers from MICASA? Or is it something where maybe there's another need, and so we try to look into that for the victim at the same time? Is address confidentiality something that's needed? Or is there anything else that we can do or provide information about the sentence for that victim? Lots of times they have questions when we do reach out about projected release dates, what the actual conviction was, what the sentence was, if there is or is not probation, those types of things. So when we're reaching out for a furlough investigation, we also do these other things. Administrative release is something that isn't often used, but if that's something that's being considered, then the victim does have the right to have that information. And we're not often involved in that process. But as far as supervised community confinement goes, I'm not sure how many folks in the audience know what that is, but we call it SCCP. Supervised community confinement. And we have this implemented in statute as an option when there are certain criteria that have been met. And so a certain amount of time has to have been completed already. And then they have to be within a certain amount of time from release, and also a certain custody level. So they have to be minimum custody level. So in order to be minimum custody level, they have to have been abiding by the rules. They cannot have any significant disciplinary history recently within the time frame, or else they wouldn't be at a minimum security facility. And this is also something that is investigated by probation. And so part of the DOC Victim Services is to reach out to the victims in those cases to see if they would like to provide input as well, the same as I had described on the furlough process. However, supervised community confinement could essentially be a longer term release, because it could be up to a longer period of time than compared to a furlough. So a furlough, they would go into the community for up to 72 hours and then they would go back to the facility. A supervised community confinement release would be similar to probation. So a probation officer would be assigned. There's standard supervised community confinement conditions that the resident has to agree to before they're released to supervised community confinement. And all of the probation conditions that would be in effect, if applicable, once supervised community confinement ends, is also part of their supervised community confinement condition. And we can also add in special conditions while they're on supervised community confinement. So it is a process in which a resident can be released to that program, and they are still considered in all means a inmate, or excuse me, a resident, but yet they're serving their time left in the community. And so if they were to violate, it's not a court process, they would be immediately returned back to the facility if that's what was determined appropriate according to the violation of their supervised community confinement conditions. And so it's really important for victims to have a voice in that process as well. And it's the same with furloughs. Sometimes there are strong objections and there's safety concerns and there's reasons why a victim is voicing an objection to the supervised community confinement. And then other times victims don't have any objections. So it really depends on a case-by-case basis. But what's really important is that the victim is able to provide input if they do in fact wish to do so. And so again, that's really important for us to have those victim notifications, so we have that immediate access to victim contact information and know that they want to hear from us. However, we will still reach out or try to locate them if we don't have a victim notification request.
But
And
Tessa,
then-
can I slow you down for a sec?
Yes.
Is it fair to say like a furlough is like the resident wants to go to a family funeral or needs to, like, I don't know, maybe go to a big medical appointment or something. It's a brief period of time, where supervised community confinement is really towards the end of the sentence, and it's going to be sort of a longer chunk of time that's considered to be served time, but it's out in the community and there are all these sort of conditions to supervise that. Is that a good distinction to draw?
It's a good distinction in the sense of with a furlough, they go back, it is for a short period of time and they do go back to the facility compared automatically without a violation compared to supervised community confinement, and they are serving the time in the community. And so they are on probation. And so instead of serving the time in the institution, they're serving the time in the community, like you had stated. And so there are different types, so back to furlough, there are different types of furloughs. And so there may be a medical furlough that might be escorted by DOC staff. So if there's a medical issue and they're escorted to the program for treatment, or if it is a doctor's appointment or whatnot, then that's escorted, and then the notification is not sent to the victim because it is in fact they call them furlough passes, and we don't share the medical information of medical appointments, and it's also escorted. So therefore it's different than a typical furlough where it is not supervised by DOC staff. And so, and that just the piece about a funeral, we call them funeral or deathbed visits. Those usually are also escorted by DOC staff, and they are a form of a furlough, except they're actually called funeral or deathbed visits. And we do reach out to victims on those to make sure that they're not at the same location or planning on attending the same, deathbed visit or funeral. And then if there are concerns from the victim, then we express that. But so those are other types of releases, essentially, where someone could go from an institution to a community location for a certain purpose and then back to the facility escorted. And so those are not actually considered furloughs, but the furloughs again are when they're released for a short period of time, not escorted by DOC staff, and then they have to return to the facility when that time period is up that was pre-designed. So for example, if it's a furlough for 24 hours to go home to a child's birthday party, then they would have the time when the furlough starts and the time 24 hours later that the resident would have to be back to the facility. Usually they have their own transportation and whatnot. And so that's always a furlough. So does that clarify the difference, Kara?
Yeah, that sounds great. And we also have a question in the chat, which is, I think this is particular probably to the furlough and supervised community confinement. I know there's a different process for parole that you can talk a little bit about, but how are the victims' views taken into account? How much weight do they receive? I think the question is sort of, how does the arbiter or the decision maker make that decision?
So what we do is we take the victim's input, and depending on what the input is, if there are significant concerns and safety concerns, then we share that information. So we share it with the probation officer. The officer shares it with in his investigation, so that those making the final decision, it's a team of folks at the Department of Corrections that make that final decision on whether or not to allow someone to go out on a furlough or supervised community confinement. The department takes the victim's safety concerns into strong consideration. However, it is not the final decision maker. And if it is denied, then the reasons are not noted because of a victim's concern, but it's noted usually as negative community sentiment, because we also don't want to jeopardize a victim's safety by having them be able to voice their concerns throughout this process. And so it is strongly considered. However, again, it is not that final decision maker, because it is a team of folks that make that final decision, and they consider all aspects, because they, as part of the investigation, the district attorney's office is always consulted with, unless it's the case is prosecuted by the attorney general's office. And then community members are also consulted with, local law enforcement. And so they take a look at the entire picture of what is being relayed. But the victim's voice is very, very important in that process. And if there are extremely strong concerns, objections, etc., then I myself ensure that that information is relayed again to the team before they make that final decision. So they're receiving it in the investigation, and then they also receive it again prior to making that final decision.
Great, thank you.
It's a great question. Thank you for asking that. So parole was abolished in 1976. And so prior to 1976, and anybody that was sentenced prior to 1976 could potentially still be eligible for parole. A lot of the folks that are still eligible for parole were murderers that were sentenced prior to 1976. And so they had lengthy sentences, and so they're still, they still come eligible for parole, usually, generally speaking, every 5 years. And we have a parole board that is not a DOC parole board. It's implemented by the governor, and the parole board looks at the cases, and there's just a handful of cases. I don't know the exact number, but it's not many that are still eligible for parole because the parole process prior to 1976 and prior was undetermined sentencing. So the sentence was really finalized at the parole board when they made that final decision to release the residents. And so now we use probation. So there's the determined time of probation when someone is sentenced. So we know how much time they will be serving, and then we know how much time will be considered for probation. Again, as we know, that's assuming that probation isn't revoked or something different happens, or sentence isn't vacated or changed, etc. But generally speaking, at the time of sentencing now, we know what the sentence is. We know how much time can, in fact, be served, and then we know how much probation will follow if there is, in fact, probation. And so that's the difference really with parole prior to 1976. And so we don't have that really anymore. And there's very few people that are actually out in the community serving time for parole at this time. So this next list is what I refer to as victim notification. So the statute specifies that a victim must file a victim notification request in order to be notified according to their rights of prisoners or juveniles release. And so when they register, it not only allows that victim to be notified of a release, it allows them to be notified of many other different things as aligned to statute. And so it's really important for victims to be able to have this notification. And this applies to a county jail as well as the MDOC as far as the statute goes for victim notification. The MDOC has different notifications that we do provide in addition to the statute because we have them outlined in policy. And sometimes at the MDOC, we have different procedures and practices than a county jail may have. And so therefore we do additional notices based upon the programs that we have at the Maine Department of Corrections. And so you'll see a lot of the different notices here that we send information out to victims on. You may have questions about, and so I will go through this list. And so some of these notices we have written out already or discussed already, but I will go in detail with these again. But what's really important to mention, I think, as far as the statute goes, is that upon request, it notes that the victim can make the request through the district attorney's office, or they can make the request directly to the Maine Department of Corrections. And so if they are working with one of you all at the district attorney's office, you can get that information to me however it's easiest for you. You can either let us know that a victim wants to be registered and give us their name and contact information, including their address and phone number. You can send it to me by filling out the form that I believe is in your computer system. And you can mail it to us, you can fax it to us, you can scan it to us. You could just type out an email, whatever is easiest for you all. Same thing for any advocates working in any of the resource centers. If you know that you are working with a victim of a case that has a protection from abuse order, they have a harassment warning, or they are the direct victim of the crime in which the resident is incarcerated, they can in fact request victim notification. And so we want to accept those requests however we can. And there's also a place on the maine.gov website where you can go to the DOC Office of Victim Services, and there's a link on our website to request victim notification. Once that's filled out, I get an email, we register the victim that way. Some victims, we take the victim notification request over the phone. And so it's however it's easiest for you all and for the victim to be able to register is what we want to accept. And so if you ever have a question about that, certainly feel free to reach out. I'm more than happy to help with that. And our goal is really to get victims registered that would like to have information about what's going on with that resident that's incarcerated at one of our facilities. And so once someone has in fact submitted that information to our office, we register the victim and we send them what we call an initial letter. So in the initial letter, it says, thank you for registering for victim notification. We have registered you at the Maine Department of Corrections. We give our contact information. If it's a domestic violence case or a sexual assault case, then we also put in a brochure from one of the coalition centers. And then we also include the DOC Victim Services pamphlet and a business card so that they have that with their initial letter. And we also write out the earliest projected release date. And then we note that that may change because as we know, and as we've talked about, sometimes someone may earn good time to the maximum amount. They may receive less of an amount. Sometimes jail time credit is given after we send out the initial letter. And so we put a disclosure on that letter that this is a projected release date and that they will get actual information as the release date gets closer for what the release date actually is. And I always encourage victims, if they're in question, to as an estimate, they can always look on the MDOC website because there's an inmate locator search on there, and then you can also find projected release date information. However, if they want the exact release date because they're a victim trying to do safety planning, then they should absolutely call because we can get them that information because the website only shows projected information. So again, if they want that completely accurate date up to date, then they should call, but we will always send it out in writing when the release date is finally determined. And we send those anywhere from 40 to 90 days or 100 days prior to the release date. The average is 88 days prior to the release that we send out the notification. And then if the date changes, then we also will provide an update. Or if we get the release address in which the resident is going to be returning to or employment information, then we'll send an update with that information as well. Because they are entitled to that information if we have it. And sometimes we don't have it immediately available when we send the first notification of release, but lots of times we have it later on. And so we do send it as we receive it. And if it's not on the notice, that means we didn't have it and that they should absolutely call, because we could also try to find other ways to try to get more information for them prior to that release. So these are the notifications that do take place once a victim has registered for victim notification. So we tell them about information about what is the sentence, where is the resident, where are they being housed. We talk about if there's an escape. I'm on call 24/7 to be able to handle those calls if there were to be an escape. And then also, of course, we would notify upon the recapture of an offender. So that's something that's important that we do, and we could provide also other additional safety planning and support services and referrals if there were to be an escape. And so we can help with that as well, depending on what the situation is in the case scenario and so forth. And then depending on what needs the victim might have in needing other resources as well. So the release notification I had talked about. And so we also notify when they'd asked for supervised community confinement. So we let the victim know that they are doing a investigation based upon the request. Same thing for furloughs. We do notify if there's been the death of an offender. I try to call, and if I can't reach someone by the phone, then I will send that out in writing for the victim. And then we also notify upon work release. So that is when someone that is incarcerated at one of the facilities has received employment. And so they usually have employment that's close to the facility. It is approved by the facility, and there's working relationships and agreements between the facility and the employers. And so this would allow either the workplace to pick up the resident, take them to the job location, and then bring them back. Or sometimes there's a other individual, or it could be a taxi that brings them to the work location and back, or an Uber, etc. And it's all approved in advance. And then there's work conditions that are also implemented in agreements that the residents have to sign before they can, in fact, go out on work release. Education release is really when they have college programming that's off-site. And so they would be leaving the facility to attend college. At lots of times now, the programming is online. And so we notify the victims that an online program is taking place via Zoom and whatnot. And then also public service release is really volunteering. And this happens a lot with the women that are at Maine Correctional Center because there's a facility across the road where the female residents can go and volunteer at the horse farm. And so it's called public service release because it's volunteering, but we also make sure that the victims know that they're leaving the facility during those timeframes. And then transfer to minimum security facility. So a minimum security facility is a facility where there's not a fence. We have two facilities, well, two for the males, one for the females, where there's not a fence. One is Southern Maine Reentry Center, where the females are in Wyndham. They're minimum security at that reentry center. And then we also have Bolduc Correctional Facility that is in Warren. And then we have a portion of Mountain View Correctional Facility that is the Charleston side of Mountain View Correctional Facility, and that's the minimum security facility. So we notify victims when a resident transfers to minimum security facilities because of the ability to start the process for re-entering back into the community and reintegrating back into the community. And so it may be these programs, work release, educational release, public service release, and whatnot. And so on our notices, we let the victims know that this may be something that the resident may be applying for in the future, and to please call us with any safety concerns or questions. And I had mentioned the funeral or deathbed visits. And so I think the last piece is the media notifications and what that is. And so the media notifications are when a interview is being requested by the media or of some sort. So for example, if one of the news stations wants to come in and do an interview with one of the residents, then we would call any victim registered on that case to ask how they feel about that. Generally speaking, the media requests do not involve specific discussions about the resident's current crime, nor do they discuss the victim. However, we do reach out to the victim to try to see if there's any additional victimization that they may be believing could happen from the media event and whatnot. And so we do get their position regarding those. And other options are when we believe that there may be some sort of publicity on social media that we become aware of, or if there's an event at one of the facilities where the media is going in to discuss one of the programs that the department is offering, or maybe like, for example, Mountain View Correctional Facility has a food service program and they do a lot of agriculture there, and they have a lot of growth in the summer for vegetables and gardening and whatnot, and they give and donate a lot of the food to the local food pantries. And so there's been a few articles from the media that have come in to write articles on that. And so from time to time, there'll be a request to involve a certain resident that might be working on that project, or ask about their opinion working on the project, or how, you know, anything it might have meant to them or their work that they're doing regarding the project. And so we would also notify the victim of that, because we want to make sure that they have an opportunity to know before they were to see something as a surprise. And also we hope that this is going to reduce any victimization that may happen if they were to see or hear something on the news or on social media that they weren't expecting. And then we also assure them as part of this, again, that we do not support discussion about the particular crime type or the victim themselves, because we want to reduce any ability to victim blame, and also try to keep any victim information as confidential as we can throughout the media. So those are reasons when we do know that that's happening, that we do reach out to the victims to make sure that they know, and then at times, if it's an interview, to see if there's any concerns. And if there are in fact concerns, and we can relay that prior to that final decision being made to allow that interview or not. Kara, are there any questions about all of the notifications that we provide that you're seeing in the chat or anywhere? I know that's.
No, I think you're all set, Tessa. That was really great. Thank you.
Okay. So some of this I've really talked a little bit about out of order, but I think it was important to give you a context about like the victim notifications. And so one thing that I do like to mention is once a victim registers for victim notification, according to the statute, it's up to them to keep us updated. Sometimes we find that we do not have updated information for victims when we're trying to reach them, or then phone numbers are outdated, which I understand people move, people change their phone numbers, but it's really important to let the victims know that they need to keep us updated. And so when something is returned from the last known address that we have, we also try many other means to try to locate the victim. And so that really is things like, you know, reaching out to the district attorney's office advocates, reaching out to the AG's office advocates, doing a LexisNexis search, trying to go back through the police report to see if we can find additional information. And so I just like to say, though, it's really important in order for us to locate people, that if they can, to please update us with any, you know, contact information that they have. And if they want it to remain confidential, our system is designed to be confidential, and only those that have access to victim services have access to who has in fact registered for victim notification. So there's a handful of us that even have access to be able to look at who has registered, the contacts we've had with those victims throughout the years, and also the information that we do have on them with their address and phone number and whatnot. And so it is confidential. But also we have had other people that want to use maybe one of the domestic violence resource centers advocates, address that they're working with, because they just want to be sure that there's not a chance that their address is not shared. So we could do that. From time to time, we have someone that refuses to give us their address. And so the district attorney's office advocate gets that notice as the victim has requested on their behalf. And so we do have ways to work around to ensure that we are honoring what the victim's wishes are. But the system was designed to ensure that the victim information is in fact confidential. And another piece is that we can also work, if necessary, to have the victim register for address confidentiality and whatnot, if that's something that they think they need as part of the resource information that we do provide regularly with victims and whatnot. And then also, if you ever are in question about has someone registered for victim notification, we could do that with a simple yes or no without sharing any confidential information. But definitely, if you think that someone wants to be registered, please reach out. Excuse me. So probation. I'm sorry. So probation, supervision, and parole. As we had talked about parole, we only have very few people that are still eligible for parole or out on parole in the state. And probation supervision is really the determined sentence at the time of one's court hearing, right? So we know what the sentence is, and we know how much probation initially is going to be part of that sentence, whether it be 1 year, 2 years, 10 years. And so probation is a program that is through the Department of Corrections, where we have a probation and parole officer that provides the supervision. And so there are many different policies that govern how probation officers supervise. There's statutes specific to probation. There are the standard conditions, as you all know, of probation. And so once someone goes on probation, they have the first, everyone has the first 11 or 12, I believe it is, conditions, and then there's added conditions from there. So the added conditions might be something like no contact with your victim, or no contact with your victim and their family, or not to go to their residence, education, place of employment. And so as those are implemented as part of the sentence and as part of the probation conditions, they're all outlined on the probation conditions document. Restitution is outlined if that is ordered. So it may say the amount, it may say in which the time frame in which it needs to be paid. It may be broken down into monthly payments or have a due date. And every particular case is different depending on how those probation conditions are written. And it becomes very important when you're trying to answer questions for a victim that may say, can I have contact or not? Or if there's a question about how much restitution was owed to a particular victim. And then also treatment. So there may be certified batterers intervention programming order. There may be sex offender treatment programming order. There may be anger management. There may be counseling to the satisfaction of probation. There may be all kinds of different treatment programs outlined. There could also be curfews listed on the probation conditions. There may be a no contact condition with a co-defendant if someone has committed a crime with another person. And then also, excuse me. Probation violations. So if someone violates their probation, there's all kinds of different things that may happen that I had discussed originally in the presentation. But what the question is, what does it mean to a victim? And so what is really important is that we relay that it could be a number of different things that could happen depending on what the probation violation is, how significant the violation is, and what is taking place with that violation in safety concerns. And so it is looked at on a case-by-case basis, depending on, again, what is that violation. But it's important for victims to know that it doesn't mean that if they violate their probation, that they're automatically going to go back and serve the suspended portion of their sentence. So for example, that we had given originally with a 10 years sentence, all but 5 suspended in 4 years probation, that resident served the 5 years that they were originally sentenced, minus their good time. They were released out on probation, and now they violated their probation. They could serve up to that remaining 5 years incarcerated. But generally speaking, they don't get that full amount of time. I have a tickle and it won't go away. So sorry.
Take the time you need, Tessa.
It's like when you don't want to cough or choke, it makes it worse. So sorry. And so with this, it's just important to know that the client will be brought back to court if it is a court sanction. Sometimes there's graduated sanctions that could happen internally between probation officers in implementing graduated sanctions. I don't know what's going on. Allergies. And so lots of times we hear from victims who have said, you know, his probation was violated. And so will he go back and serve the rest of the time? And that's not always the case. So I think it's just really important to be upfront with the victim to let them know that will be determined on a case-by-case basis, depending on the situation and what the violation was.
So Tessa, a couple questions for you. One quick thing that I think is a sort of practical issue. I'll let you take a second. So the question is, what should a victim do if they witness or experience a violation? Let's say there's a no contact and they know the person's on probation and they violated that probation condition. Who should they tell?
So I think that can be twofold. And if they are concerned for their safety, then they absolutely should report the violation to law enforcement. If it is considered more of a minor violation and they want someone to know, they could call the probation officer. And so if it is, depending on what the violation is, again, so if it's a new crime, then it should always go to law enforcement as well. But if it's just information that they want probation to have, and then probation can determine, you know, is that information confidential according to the victim or not? Maybe it's just more information that the probation officer would have. And every case is handled differently because it depends on what the violation was and if it resulted in a new crime. And so if it's a new crime, absolutely, I would suggest that they report it to law enforcement first because they could go and do an investigation. But then if it's just information they want probation to have, then they could let probation know about that. Now, if there's also a protection order or something of that nature, then I would also encourage going first to law enforcement. If it's a situation where a victim doesn't want anyone to know that they are reporting this violation, if they're not going to law enforcement, then they can always let probation know, but it's not protected information once it gets to probation. They can ask for it to be confidential, and the probation officer can try to do the best they can to work with the information that they have. But it also depends on if the victim is willing to write out a statement, if they're willing to cooperate, if there were to be an investigation done by law enforcement. And so I think that's a really tough question. And I think that it would be a matter of preference of what each individual probation officer would be able to do. But again, I would say that they should report it. But definitely if it's a new crime, they should go to law enforcement first. And if there's safety concerns, because they want to be able to be safe and have it investigated, which probation may not have the full ability to go out and investigate because that's not their primary function. But yet they could take the information that's given to them and they could potentially file a probation violation with that information. But generally speaking, it should start with law enforcement because they do have that ability to go out and do a full investigation of what is happening. And then they can also contact probation.
Got it. This next question has to do with sort of the suitability of residences for clients. And I suppose this could apply too if we were talking about early release of someone who's incarcerated. But how does DOC determine whether the address that the client or resident has proposed is appropriate, that it's a real address, that there aren't other people who they shouldn't be with in the residence, and who does that? Who looks into that?
So probation, if there's probation, then probation looks into that. Now with COVID, things looked a little bit differently because there wasn't always an ability to go out to homes, into the communities and whatnot. So that looked a little bit differently. But generally speaking, probation will go and look into the release information to ensure that it is appropriate. Now, some probation conditions actually say that they can only reside where approved by probation and parole. And so if that's the case, then probation and parole does in fact actually have to approve it. But if it doesn't have that condition, then they go out to ensure that it's actually just a location and that there isn't, some reason that is clearly visible and why that resident couldn't be released there, such as if there's firearms in the home and the resident isn't supposed to have firearms. Now that is absolutely done on furloughs and supervised community confinement because the probation officers, while doing their investigation, ensure that the residents in which they're proposing to go to and the sponsors on a furlough are appropriate and that the home is appropriate. The same thing with supervised community confinement. Now, a regular release to probation is aware and they look into ensuring that there really is a location there. But again, it was just a little bit different during COVID for a while when they were not going to the actual homes. But generally speaking, there's this authentication process to ensure that it is actually a residence or a location. And we've had questions come to us before from victims to say that they Googled an address and it isn't really a location, or they've gone by and it's a field, those types of things. And what we do is we can go back and say, can you get more clarification on this address? Was there maybe the wrong number? And then sometimes, it may be something such as maybe a camper on the middle of a lot. But if the probation conditions do not restrict where they can actually live, then generally speaking, as long as it is literally a camper on a lot, then they're likely to approve that location. So there are the checks that are done by probation, or at least, looked into before they're released, but then after they're released, then there's more checks done because it's a process for home checks as well as in-person reporting, generally speaking, prior to COVID and whatnot. So there's standard reporting options that have to be done by probation according to the risk level that's been determined by the probation policy that applies to each individual. So every probationer is assessed a risk level, and then that risk level determines how much a probation officer goes for, home checks, in-office checks, employment checks, those types of things.
Great, thank you, Tessa.
Sure, great questions. Were there any more pertaining to that?
That's what we've got, yeah.
Okay. So the important piece for me is that when someone is sentenced, that we know what that determined sentence includes for probation or not. So we know if there's probation or not. And if there's not probation, then we let the victim know that. And then we can also suggest, any type of additional safety planning they need, or if they should get a protection from abuse order, those types of things prior to release. And then also if there is probation, we would still recommend those things, but then we also have a little bit more information we can share as to what will happen next when one is released to probation and what probation looks like. So we work a lot with victim restitution as well. And so this is something that we work with once in either someone that's incarcerated or someone is out on probation with a court-ordered restitution. So once that restitution has been ordered, then we can work with the victims to explain what our process looks like, where we can collect, how much we can collect. And so I think it's important for the advocates to know that if someone has been sentenced and they're serving a term of incarceration at the DOC, that there are abilities to earn funds. So lots of the jobs are minimum wage paying jobs while they're incarcerated. And so there is an ability to earn and pay back victim restitution. And then also there's an ability to earn and pay back restitution when they are out on probation. And we also garnish all Maine revenue refunds for anyone that has outstanding restitution obligation, since it's considered additional funds or additional income. And so we also collect that for victims. And so we also would refer victims to victims' compensation if the person that's either incarcerated or out on probation does not have any monies coming in or isn't paying the restitution, and victims' compensation seems to be applicable, then we would be able to do that and make sure that they're getting that avenue as well. And then if for some reason victims' compensation pays, then we would reimburse victims' compensation after we've made sure that the victim was reimbursed in full as well, assuming victims' comp didn't cover all the expenses. And so when someone is incarcerated at a DOC facility, we take 25% across the board from all funds that they receive, unless it's the phone account. The phone account is the only one that we're not able to garnish restitution from. And so whatever monies they get, we take 25% towards their restitution obligation. Now, if they're out on probation and the court order does not specify the payment plan, then the probation officer must determine the payment plan according to their ability to pay. And so there's a policy that outlines what the payment plan should be, and the minimum amount is $25 a month. And so when that money comes in from either the residents or the clients out on probation, we get that money sent directly to the victim from the restitution fund in Augusta. And so part of the advocacy that we do as well is working with victims to say, oh, we have funds available, we'll get that sent to you. If we can't locate a victim, we try to find a victim and get them their restitution. Lots of times there may be an issue with a restitution case setup that we need help with. So Lynn may reach out to the district attorney's office, for example, to say, are there co-defendants? Can you tell me who the victim was? What do you have for information? And so those are things that we work on to try to get that victim's restitution paid out to them as seamless and as quickly as possible. And so if we can't locate a victim, we try everything we can think of to try to locate the victim. Sometimes we still can't locate victims, and our current practice has always been, when we can't locate victims, to send that money over to the treasurer to be held for them, to be able to claim at any point. And so we had a lady who had contacted us who had a 23-year-old case, and this was a few months ago. And so we had sent her funds to an unclaimed property over at abandoned property at the treasury. And so she was able to claim those funds that were still there for her to claim. And so I think that that's what was originally intended and so forth. So that's what we do. That's our current practice. That may change in the future, but currently we do all that we can to try to locate victims and to get them the money that they're owed. So if you're working with a victim that thinks that they might be owed restitution, give us a call because they may have funds sitting and available for them that we just weren't able to locate them. So just a point out there, just in case. You never know. So a couple of the different programs that we have that DOC Victim Services is involved with is the Batterers Intervention Programs in the community. And so the Office of Victim Services statute talks about the oversight that I provide for the certification of the Batterers Intervention Programs in the state of Maine. And so we have programs in every county of the state for male and female offenders who have been court-ordered to attend certified Batterers Intervention Programs. So currently in our state, only the certified Batterers Intervention Programs can accept court-ordered probationers to attend. So for example, if it's not a certified program and there's someone that has a condition to attend a certified Batterers Intervention Program, they cannot attend that particular program that's not certified. They can only attend a certified program as according to the Batterers Intervention Program standards and according to the state statute. They're 48 weeks in length. They are 48 weeks long. They cannot double up. They're 90 minutes each, and again, certified by the Maine Department of Corrections. And so if any of you are not familiar with your certified Batterers Intervention Programs in your community, I would encourage you to reach out. One of the really important pieces about certified Batterers Intervention Programs is the coordinated community response, which is a communication that happens between different agencies and stakeholders to ensure that there is, communication going on and hopes to hold offenders accountable. So if you don't know who your Batterers Intervention Program is in your community, please reach out to me if you'd like. We can find that information for you. It's important to have relationships with them. And also part of the Batterers Intervention Programming is that the BIP, as we refer to them, or CBIP, they must reach out to the victim to notify the victim that the offender is actually enrolled in their program, unless notifying that victim would cause safety concerns. But generally speaking, the program does reach out, and then they also work in close collaboration with their local domestic violence resource center. Any questions about Batterers Intervention Programs?
We don't have any in the chat.
Okay. So a segue from the Batterers Intervention Program is going to the DOC facility programs. And what I like to point out is that our programs are not certified, and they are not certified Batterers Intervention Programs. They're different. However, they are similar in the sense of trying to address domestic abuse issues. So credit is not given for attendance in one of the DOC facility programs. So for example, if a probationer has a condition to attend certified Batterers Intervention Program, but they attended one of the DOC DV programs, they still have to complete that certified program in the community. And this is according to the statutes for the Certified Batterers Intervention Program rule, as well as the non-certification that we have for the programs at the DOC. So I bring this up because it's still important for everyone to know that they are receiving some form of programming while they're incarcerated. It's just not the same thing as the Certified Batterers Intervention programs. So our programs are called, it was called FVEP, which was Family Violence Education Program, which was based upon the Duluth model for those that are incarcerated. But then we used CBI DV or IPV for intimate partner violence. And so that's driven from the University of Cincinnati's program, who also offers our facility substance abuse treatment programs and whatnot. And then we also have what we call SAFE, which is a shortened program. It's usually anywhere from 8 to 12 weeks or so. And that is done in curriculum format for the lower risk residents that we have. And so these are all designed to address domestic abuse issues while offenders are incarcerated. And so this goes on to the mail, phone, and visit policies and our policy 6.3, which is really another segment. And so what's important about those policies is that if someone does not want contact with a resident, or they don't want their children to have contact with a resident, or there's unwanted contact, or there's concerns, that we can prohibit the contact through the mail, phone, and visit policies. And so if there is someone that is receiving unwanted phone calls, they can call the facility, or they could call us to say, I'm receiving these calls, I don't want the calls, can you please block my phone number? So all they need to do is submit that request, and then we can block their phone number for them. And the same thing in writing. If someone's receiving letters that are not wanted, then those policies can assist people in the community from having these unwanted contacts. Now, this goes on another step further with policy 6.3, which is contact with victims. So if there are probation conditions prohibiting contact with a victim, and those probation conditions are in effect, will be in effect, or were in effect, but the probation was fully revoked, then we honor all of those conditions while the residents are incarcerated. And that is a blanket restriction on contact. If there's a probation condition, if there's a protection from abuse order, if there's some court order prohibiting contact, we enforce that while the residents are incarcerated. Now, if it's a new crime, then victims should always report that to law enforcement and or to the DOC. Law enforcement in the communities can investigate that, or the DOC also has investigators that are law enforcement that can look into those crimes as well. And the DOC Victim Services can absolutely assist with that as well. So it's just an important resource to have, and to know that we enforce those conditions even if probation is revoked in full. And so the policy 6.3, contact with victims, allows for domestic violence victims, sexual abuse victims, child abuse or child neglect victims to ask for contact if there is not already a court-ordered no contact. So if someone wants contact, either if the resident wants contact with a victim, or if a victim wants contact with a resident, they must go through the waiver process. And that is all outlined in policy 6.3, contact with victims. And so those requests are reviewed by myself. Nicole Fallon prepares those for me in the office. And then we make a decision on whether or not to allow contact, assuming there's not already a court order prohibiting contact, because I cannot override a court order. But we also reach out to victims if we're considering allowing contact, because we would not grant contact if the victim doesn't want contact. So sometimes this is also a way for victims to be able to request no contact, in addition to just calling the facility to say, please block my number. Especially if there's safety concerns or if there's other concerns. Those are things that we can try to help the victim with, especially if it's domestic violence, sexual abuse, child neglect cases. Now, an open DHHS case would mean that the resident is initially prohibited contact with the children because of the open DHHS case. When we look into it further, we consult with DHHS to see should contact be allowed or not. But so to just give you an idea about the child abuse, child neglect, if there's an open DHHS case, it's automatically child abuse or child neglect. If there's a protection from abuse order for that child, then it's child abuse. If there's an endangering the welfare of a child charge for driving recklessly in a car with the child as a passenger, then that would be child abuse. Now, if it's neglect because there may be substance use happening frequently around a child, then that would be more child neglect. Unless, of course, the law enforcement were called and they were charged with endangering the welfare of a child for a particular reason, then it would go to child abuse. But either way, our policy prohibits contact with anyone that falls under that particular category, and the waiver process applies. So lots of times victims believe that probation conditions are no longer in effect while one is incarcerated, which isn't accurate. Some victims believe that if the court didn't prohibit contact at the time of sentencing, then they shouldn't be prohibited contact while the resident is incarcerated. And so these are just different things that we go through, and we can talk with the victim and explain the process. We can make sure that they have other advocates and resources to assist them as well. We always refer again to the coalition resource centers. And so those are things that we do review, but again, we would not approve contact without that victim's permission. So it's important that we get that position from them. And then we can also protect their information if they have safety concerns. And so that information is not shared back with the resident. But so I bring this particular subject up because this is a policy specific to the Department of Corrections, but we can also, according to Maine statute, revoke probation if they are in fact contacting their victim that they should not be contacting, either because of a probation condition or because of our DOC policy while they're incarcerated. And so it's just good information that I like to share in case you're working with somebody that may have questions about this. And we're always available to help if anybody has questions at any time. Victim offender dialogue is a restorative justice option that we have. And I have a policy, we have a policy at the Department of Corrections that applies to this and our residents that are incarcerated. And then this is a victim-initiated, victim-centered approach. So if I could encourage all of you, if you're working with any victims or survivors that you think might want to have a victim offender dialogue, please just let them know that this is an option, because it does have to be victim initiated. The initiation can't come from the residents. It has to come specifically from the victim. That's national best practice according to the National Association of Victim Advocates and Corrections. And so we have that policy implemented. And this really is a process that can be really restorative if the victim is in a place where they want to have this, and if the resident has agreed and admits the crime. And so what happens is both the victim meets with a facilitator separately and the resident meets with a facilitator separately, many times in preparation for the actual dialogue, which would be a one-time meeting with the victim or survivor and that resident to talk about the crime, the harm it caused, and try to repair any harm that they can. Sometimes it's for a victim or survivor to get questions answered that only that resident can answer. Sometimes it's really restorative and healing for both parties. And so it's set specifically for the one-time meeting with that trained facilitator to talk about the facts and the feelings about what happened, what took place, the impact that that crime had. And it can be extremely powerful. And so it's not really a mediation or reconciliation process. It's really just to talk about the facts as it was initially requested and driven by the victim. And so then we also need to have medical clearance for the residents prior to this and whatnot. But if there's any requests that you have or any victim that you think might be interested in this or that you think would be helpful, please have them reach out or reach out for them. We can talk about it further. It is confidential. There's a contract that must be signed to ensure the confidentiality. Can't be recorded or anything of that nature. And then I would go with the victim as to be there for support during any breaks of the dialogue, and then follow up after. And then the facilitator also does the debrief. And so we do have a volunteer expert trainer and facilitator that we have here in our state. So we're very lucky to be able to offer this as an opportunity. And so please, if there's any more information at any time we can give, let us know. So harassment warnings are what I had mentioned briefly that we can offer to community members that believe they're being harassed. They can already be a victim of that current resident, or they might feel like they're being harassed in by other means. And so we can take a look at that case and assist that victim or community member with that request to get a harassment warning served. And so DOC Victim Services can help anytime with any of those. Or if there's a preference, you can contact the facility law enforcement directly. But it's outlined in statute that this is an option. It is the same as a court-ordered harassment warning or a harassment warning issued by law enforcement. The difference is the DOC harassment warnings are in effect as long as the resident is in the care or custody of the Department of Corrections. So therefore, it applies to even after they are released, if they are in fact released to probation. Victim-centered safety planning. This is something that's really, really important to us. And we offer this for any victim of any crime, for anybody that's being released to the community from incarceration. We specifically reach out to victims of sexual assault when a registered sex offender is being released to the community, or when we have a domestic violence offender being released to the community. We reach out to both of those victims, even if victim notification hasn't been requested. And we say in our reach out letter who we are, that we're offering a safety planning meeting. If they would like to register for victim notification, please contact us. We give the projected release date information. And it's a way for us to ensure that victims who may not ever reached out to us before do at least know that that person is going to be released to the community. And so part of that, if a victim requests a safety planning meeting, we have that victim-centered safety planning meeting based upon the needs of that victim. So we invite who the victim would like to have at their meeting. It is held confidentially. We have probation. If they're acceptable to having probation at their meeting, go through any probation conditions if applicable. We talk about the terminology that the advocate would have explained about what the probation conditions are, what they mean, what happens next. And then we also have that probation officer go over them again to reiterate, because lots of times victims are not familiar with the terminology that we're familiar with because we see probation conditions regularly. And so we know what, the difference is between no use or possession of alcohol compared to no excessive use of alcohol. And so what is the difference with that? And so excessive use is when it's a legal violation, so 0.08 or more. No use is just that, no use of possession. You can't be drinking. And so we explain those types of things. We talk about, what does no contact mean? What do you do if you're in Walmart and you are at one aisle and the probationer is at the other end of the aisle? What happens then? And so those are things that we discuss, which the probationer is supposed to turn and walk away and report that to their probation officer. What happens if there's an interaction? You know, are there gestures? Is it, we need law enforcement. That's what we talk to the victims about, is, you know, what to do if this particular incident happens. We can ask others. We always encourage, if it's a domestic violence case, to have the Domestic Violence Resource Center advocate there. Same thing for it's a sexual assault case. And so we want to make sure that we have the appropriate resources and information for that victim at the safety planning meeting, so that they know what the information is about what's happening. They know when the release will take place. They know where they'll be living, working. We can also include law enforcement. Law enforcement's a great asset to the team, because they can also share information with their other law enforcement agencies in the area where maybe a victim lives, or where the resident is being released to ensure that there's this additional information sharing, which can help to make the victim safer. And so those are what we offer, facilitate, or organize and facilitate upon a victim's request at any time that they were to have one. And again, it's not specific to DV and SA cases. However, it is really important that everyone knows that we can also do safety planning for someone that you might be working with. If they think that that's something that is helpful to them, or you think it would be helpful, you could always make that suggestion, or we could work with you if you're already doing safety planning. You know, are we able to provide something that might be helpful? So just reach out. We're more than happy to try to help with every situation the best that we can. So I'm aware of the time here, so I'm just going to go through. There's just a few more things here. And I wanted to leave some more time for questions. But so there is a statutory right for victims to participate at sentencing. And so we've used the national term, right? Victim impact statements. And so it's just a form that you can use. We use it when we try to get information from a victim regarding a furlough or supervised community confinement investigations. However, sometimes a victim doesn't want to use the form, and so we could just use it as a starting point, because sometimes victims don't know where to start with how they feel. And so it's really important to just say, you know, this is just a guide. If you want to use it, you can. You don't have to use it if you don't want to, or you can just talk to me and I can summarize this for you. And so I just think it's important that everyone knows that that is something that we do use and offer to victims when we're trying to get feedback from them, but sometimes it's not necessary, or they just don't want to submit one, which is absolutely fine as well. And so additional assistance that we can provide, we can give victims a photo, or if there's a staff victim, we can work with staff victims and getting them a photo. If there's a conflict case and someone has worked with us for so long that they really just don't want to work with anybody else, then sometimes we've tried to arrange a direct contact to get a PFA. Like, I reached out to the domestic violence resource centers before saying, would you please help this victim? I've given, information. We've given information about the protection from abuse orders, the helpfulness that they are. And lots of times, even if there's not, if there is a probation condition of no contact, it's still important to have a protection order, because then there could be, if there were contact violation, then it could be a new crime and a probation violation. But so we just provide a lot of information about what a protection order is and how they can get one, and then referrals, of course. So we've talked about that. With the court documents, we really just want to make sure that they understand the terminology. So we're always talking about what the particular language means. What does no contact mean? It means that they can't contact you directly or indirectly. They can't send you flowers. They shouldn't be calling your phone. They shouldn't send you a letter. They shouldn't relay a message to someone else to tell you something. Those are all indirect contacts. So those things we talk about. We refer to address confidentiality when appropriate. And then, of course, any additional information that comes up with a case, if we think there's assistance needed, we always provide that. And then I always talk about if there's a pre-incident, which is the Prison Rape Elimination Act. If there's an incident or rape, sexual assault, etc., in one of our institutions and charges are brought, that victim is still eligible for victim notification, even if they're incarcerated, because it doesn't matter where one is, they're still eligible for victim notification if they are a victim of a crime. And it doesn't matter the age of the perpetrator either. We can offer victim notification on adults and juvenile cases. And so these are just a few more policies that we have. The 6.0 is really just the Office of Victim Services, which is driven from the statute that I shared with you at the beginning. And if you ever want to look at it in full detail, it's 34A 1214. We also have policy 6.1, which outlines the timeframes we have to notify victims and when and how. So for example, for a notification of release, we try to do it no later than 30 days prior to release. Our average is 88 days in advance. And so also, when we notify on furloughs, if there's supervised community confinement, we notify 14 days in advance, those types of things. And then of course, most importantly, the confidentiality of victim information. And so we cannot release information from a police report, victim's contact information, phone numbers, etc., without that victim's permission. And so there were a bunch of different brochures and pamphlets that we can get you at any time. The DOC Victim Services pamphlet is specific to DOC, but then we also have the Victim Witness Advocate brochure that we print for all of you at the district attorney's office to distribute. So if you need more of those, please give me a call, send me an email. We'll get you a bunch, however many ever you need for your office, that talks about victims' rights and services and has all the victim witness advocates contacts and whatnot. And then also, of course, my phone number and the 800 number for victim questions or inquiries, or any of you at any time. Please don't hesitate to reach out if I can help you in any way, or if you're working with a victim and you think there's anything that we could do to offer for services, or even if you just want to brainstorm if there's something we can do that might be helpful or not. And so this is really just more information that talks specifically about how we do the notifications. And so a lot of this we have talked about, and it just really is just, the who, what, where, when, and whys. I don't have a why. Who, what, when, where, and how. We do the things, but this is stuff that we've talked about really already. And last but not least, questions. Are there any other questions out there?
Thanks so much, Tessa. I don't have anything in the chat, but if people want to put questions in the chat or unmute themselves to ask questions, that would be great. There is a lot that you all do in victim services and a lot that you need to know about for corrections. It's a pretty impressive piece of work.
So could I ask one question?
Sure.
Were there early releases because of COVID?
We didn't have early releases completely because of COVID, but what we did have was supervised community confinement applications that had come through. And so we had a process that had been the same process we had always used when COVID did come in. And so we did have cases that were coming through because of COVID, or requests that we had because there were concerns for a particular facility, or sometimes even just a resident might have had a concern. And so if they were fitting the parameters of what we had already implemented for the supervised community confinement criteria, then they were in fact able to apply. But it was that full process. We didn't just release any resident because of COVID. We did release people onto supervised community confinement.
And could you repeat where the female facility is today?
Yes, that's Southern Maine Reentry Center. and it is next door to Maine Correctional Center. It's on the same property in Wyndham.
So there were always female pods in Wyndham. Is that not where they are now?
There are still females in the female section of Maine Correctional Center, but the minimum security female residents are at Southern Maine Reentry Center, which is next door. It's a building next door to Maine Correctional Center. So there are females at both locations, depending on their security risk.
Got it. Okay.
Because they have to be minimum security or community to go to Southern Maine Reentry Center.
I see. Thanks.
You're welcome.
Very good presentation, by the way. Thank
Oh,
you.
thank you.
That might be it for you, Tessa. I think, I mean, it was so thorough, so much great information, and folks know how to find you. Thank you so much for taking the time today.
Thank you so much, Kara, for arranging this, and I appreciate everyone attending. It's so nice to be able to talk with you, and hopefully next time we'll be able to be in person someday here soon.
Thank you so much. Have a great day.
Thank you. Bye.